let's talk about something that's, well, it's incredibly personal and tough. GP negligence claims right here in Scotland. We're going to break it all down. Have you ever just had that feeling that the care you got from your GP wasn't quite right? It can leave you feeling confused, even a little bit lost. So what we're going to do here is give you the clear, straightforward info you need to understand what's what. All right, first up, let's talk about why the role of a GP is so fundamental to our healthcare system in Scotland. Think about it. Our GP is pretty much always our first stop. They're the gatekeepers. From a new symptom to managing a long-term condition, we put a massive amount of trust in them. And, with that trust comes a really serious legal responsibility. It's something called a duty of care. Okay, so what happens if you feel that duty of care was broken? How is that actually judged in the eyes of the law? Turns out, it all boils down to one specific legal test. So what is this duty of care? Well, at its core, it's just a legal way of saying your GP has to provide a certain standard of skill and care. It's what any patient should be able to expect. Simple as that, really. Right. Here's the key thing you need to know. In Scotland, any claim of GP negligence gets measured against this one specific legal standard. It's called the Hunter v. Hanley test. It's been around for a while, since 1955 actually, and it's got three main parts. Okay, let's break this down because it can seem a bit complicated. First, you've got to show there's a usual and normal way to handle the situation. Kind of like, here's what a GP would normally do. Second, you have to prove that your GP didn't do that. They went off-piste, so to speak. And then the third part, and this is the absolute kicker, you have to show that their decision wasn't just a different choice, but a choice that no other GP with ordinary skill would have made in the same circumstances. That's the real hurdle. Now, I know that legal test can sound a bit abstract, so let's make it real. Let's look at some of the common situations where these claims actually come up. You see a lot of different things, but some patterns do emerge. We're talking about things like failing to diagnose or refer for something serious like cancer, making mistakes with prescriptions, or missing other major conditions like meningitis or a DBT. It could also be about not acting on weird test results, or maybe not managing a chronic illness like diabetes properly. Even failures in mental health care can fall into this. Seeing these might help you see if your own experience fits a pattern. And here's a perfect, really simple example. Let's say an abnormal blood test result comes back to the practice. What's the standard procedure? Well, the GP reviews it and they get in touch with the patient for a follow-up, right? But what if that result just gets filed away? No action taken. And because of that, the patient suffers harm. Well, that's a clear breakdown in the standard process, and that could absolutely be the basis for a negligence claim. Okay, so if any of this is starting to sound familiar, you're probably wondering, what do I actually do? Let's cover the very first steps you should take. Now, before we go any further, this is probably the single most important thing to grasp. Your medical records are the absolute foundation of any case. Why? Simple. They are the objective evidence. They're the official story of what happened, when it happened, and what was said. Everything else is built on top of them. So, what's the game plan? Well, it's actually a pretty clear-cut process at the start. Step 1. Talk to a specialist solicitor, and I mean someone who really knows clinical negligence inside and out. Step 2, they will then get hold of your full medical records for you. And step 3, those records are then handed over to an independent GP expert who gives their professional opinion on whether the standard of care you received was, well, up to scratch. Oh, and here's a quick but important point. The claim itself isn't usually against the individual doctor you saw. It's brought against the GP practice as a whole. Legally, the practice is responsible for its staff. Now, through all of this, there is one factor that looms over everything. One thing that is absolutely critical, and that's time. And when we talk about time, there is one number you have to burn into your memory. 3 years is the standard time limit you have to bring a claim in Scotland. It's a strict deadline. But, and this is a big but, when does that 3-year stopwatch actually start ticking? Because here's the thing, it's not always on the day the mistake happened. This is where we get into a really important legal idea called the date of knowledge. Basically, the clock only starts running from the moment you knew, or importantly, should have known, 2 things. 1, that you'd been harmed, and 2, that the harm was probably linked to the care you got from your GP. So, for example, the clock might not start until the day a specialist turns to you and says, you know what, this should have been spotted a lot sooner. All right, we've covered a ton of information. So for our final section, let's pull it all together and figure out the main takeaway here, your path to getting some clarity. We have to remember this isn't just about legal rules and timelines. The relationship we have with our GP is built on a foundation of trust. And when that trust is broken, it can feel incredibly personal, really distressing. It's a huge deal.
So let's do a quick recap of the must-knows. First, that Hunter v. Hanley test is the legal benchmark. Second, your medical records are your most powerful piece of evidence, period. Third, you've got that strict 3-year time limit. But remember, your date of knowledge is the key to when it starts. And finally, and maybe most importantly, your very first step should always be to get advice from a specialist.
So at the end of the day, if you're sitting there with that nagging feeling that something just went wrong with your care, the most important question you can ask yourself isn't actually, do I have a case? No, the real question is this: have I sought expert advice to find out? Because taking that first step, well, that's the only way you're ever going to move from that place of worry and uncertainty to a place of real understanding.